pop up here to remind me to log in. So, all right.
Quick interjection. So if you just want to jump into, do you have your presentation available on your computer?
I have it available for me. Can you hear me fine?
I can hear you fine.
Okay, so yes, I will go through and I just let people know when I'm going on to the next slide, I guess. Okay, and I did not probably have a full hour's worth of material anyway, so but I am sorry people had to wait there for me to log in. So if you go to the second slide, just the objectives really are to understand the current laws and statutes, well, laws and rules, I should say, that concern the sale of CBD products that are derived from hemp. And then to understand some changes made by the Minnesota legislature in 2019 that will, if certain conditions are met, allow for the legal sale of such products, at least under state law. But as I'll explain, that doesn't mean that it will be legal under federal law. And just as a way of background, go to the third slide. I'm going to talk a little bit about cannabidiol, but as a way of background, I just want to let you kind of know what the board's been doing, how the board became aware of this, our board, and how this kind of give you a little bit of a idea of how this all came about. So I was first alerted to this issue that there were these products out there that were being sold over the counter basically everywhere, from grocery stores to gas stations. You know, after I found out about this, I went to my own veterinarian's office, and that veterinarian was selling a product I think was called Pet Paws. But I only became aware of this maybe 14 months ago, late summer of last year, when I was brought into an existing dialogue that had been going on between the Minnesota Department of Public Safety and local law enforcement officials and the Department of Agriculture. And the reason the Department of Agriculture was involved is that back in 2015, as I'll explain further, our legislature created an industrial hemp research program that is under the jurisdiction of the Department of Agriculture. And so law enforcement knew that, and so law enforcement was going to the Department of Agriculture about these products that they were sometimes seizing during a stop. They were wondering if this was legal because it's derived from a cannabis plant. Sometimes they were actually going into stores that were selling it, purchasing samples, if you will, and then sending it off to the Department of Agriculture to question the legality. Well, sometime last summer, a gentleman by the name of Brian Marquardt at the Department of Public Safety, who I've worked with for many years on other drug-related issues such as synthetic street drugs or methamphetamine and things like that, he finally sent an email and said, "Has anyone asked Cody at the Board of Pharmacy to weigh in on this?" And no one had at that point. And so when I found out that these products actually existed, I started doing a bunch of research, and I'll explain some of what I found out when I looked into the applicable federal and state laws. But my conclusion was that these products are not legal, and that's kind of one of the focuses of this talk today is why that is, why the products aren't legal, and then basically to explain what's happened since last summer when I kind of became aware of this. So you probably know that cannabidiol, CBD, is one of many dozens, if not hundreds, of chemicals, cannabinoids, that are found in cannabis sativa plants, all types of cannabis sativa plants. And it is pharmacologically active. That's kind of important because some of the sellers are trying to sell these products as if they were dietary supplements, but actually I would consider cannabidiol to be pharmacologically a drug. It's also legally a drug, as I'll explain, but it acts not just on endocannabinoid systems in humans and animals, it also acts on other signaling systems and other types of receptors, including, I think most importantly, serotonin receptors. And of course, the reason that's important is there are a lot of medications, at least in the human world, and I'm not sure how much they're used in the animal world, that affect serotonin receptors. So antidepressants, they're called serotonin, selective serotonin reuptake inhibitors, right? They affect the serotonin system. So that means that CBD can potentially pharmacodynamically interact with a bunch of other drugs that are on the market, again, at least in the human world. And it can also pharmacokinetically interact with a bunch of drugs that are on the market because it's metabolized by that cytochrome P450 enzyme system that metabolizes probably 40 to 50% of the drugs that are on the market. The FDA-approved drugs on the market are metabolized by that same enzyme system, and CBD acts as a competitive inhibitor. So that means if you have enough CBD on board, you're going to slow the metabolism of these other drugs, and in some cases that can result in toxic levels of the other drugs being built up. So the fact that this is pharmacologically active is, I think, really important here for our board when we're looking at public safety issues. And we see a product that can both pharmacodynamically and pharmacokinetically interact drugs that are on the market, or just by itself, because it does act on all these signaling and receptor systems, can itself produce side effects. It's really something that we would be concerned about if it's being sold over the counter, it's being manufactured by unregulated companies, being sold by, in some cases, it's one thing for a veterinarian maybe to sell this, it's a totally different thing for the clerk at the grocery store down the street to be selling it when it's pharmacologically active. So there are, as you probably know, a large variety of products, both for human and animal consumption, being sold. They are everywhere. As I've told the media when I've talked to reporters about this, it's like the wild, wild west out there. There are, I think, hundreds of sellers of products like this in Minnesota, actual bricks and mortars facilities or stores or whatever selling the products. There are probably thousands of websites selling it, probably dozens to hundreds of manufacturers. And it's in everything from food products, which are not under the board's authority, CBD gummy bears, cookies, caramels, and it's also in more drug-like products, tinctures that are meant to be administered sublingually, topical creams and balms, which is kind of interesting because there's some data that CBD really doesn't penetrate through the upper layers of the skin. So unless it's having a local effect, it's probably not doing anything. So just a variety of different products that are out there. Now, so the question might be, if these are illegal, why are they being sold? And I think it's because there was a fundamental misinterpretation of a piece of legislation that Congress passed back in 2014. And what that did, it was just a very small provision in the 2014 Federal Agricultural Bill, or sometimes it's called the Farm Bill. And literally, it wasn't a full page of text. And all that little bit of language did was allow for the cultivation of hemp, and it defined hemp as a cannabis plant with less than 0.3% THC, which is the cannabinoid, the primary cannabinoid in cannabis plants that gets people high. That's why people smoke marijuana, is for THC content. So that's a legal definition here, is hemp is a cannabis plant that has less than 0.3% THC, and the same plant, if it had, say, 1% THC, is marijuana. So this is a legal distinction, but they're really different varieties of the same plant. There's sometimes, like, hemp is called the cousin of marijuana. It's not. It's the same plant. It just has a lower level of THC in it, and it can be bred that way. There have been naturally occurring cannabis plants, over the probably millennia, because cannabis has been used recreationally and for medicinal purposes for like thousands of years. And there have always been natural varieties that have had low levels of THC, but the plant breeders can actually breed the plants to have higher levels of THC, lower levels of THC, higher levels of CBD, and some of them actually try to get what they believe is a good ratio of CBD to THC to do certain particular things. So what that bill did, at any rate, was to allow for the cultivation of hemp for, and I emphasize this in the slide, research purposes as part of agricultural pilot programs. Though that bill never allowed for the generalized commercial sales of products that contain CBD extracted from hemp or from hemp itself. The one bit of language in this bill that I think people incorrectly latched onto is it said the research could look at cultivation, production, and marketing. So they jumped to the incorrect conclusion that since they were allowed to do marketing research, they could somehow just have generalized commercial sales of the products. Well, that's just not the way you interpret laws, first of all. And secondly, you can do marketing research without ever selling a product. Pharmaceutical manufacturers do it all the time. They hold focus groups of prescribers to get some idea about what the reception for this new drug will market and how they might direct their marketing campaigns and things like that. So, but there's nothing in there that allowed them to do it, but nevertheless they did, based on a misinterpretation that somehow marketing research allowed for these generalized sales. Well, by the time that the FDA and the DEA and the U.S. Department of Agriculture kind of realized that these products were out there and spreading, they issued a joint statement in 2016 indicating the products were not legal, but the sales continued anyway. And that statement very clearly says what I just outlined. It's like nothing in that 2014 bill allowed any sort of generalized sales of the products. And at that time, the DEA was also concerned that it was still a controlled substance. And I'll get back to that issue in a little bit. So going on to the next slide, slide 4, this is just an example of some marketing for one of the products. This was given to me by the Department of Agriculture. And there are some important things to point out on this slide. And I'm going to come back to these slides when I get to the slide that explains what's wrong with this. But for now, I just want you to see this is just one example of the marketing. You've probably already seen marketing yourself. You may have been approached by companies that want to sell it and seen this sort of marketing. These are some things that law enforcement bought and brought into the Department of Agriculture for testing. And again, I'm going to come back to these and point some things out in particular about this. This is quite interesting. This is a CBD hemp cigar. And notice it says that it is medical grade hemp in a cigar. That's interesting, but we'll come back to that again. And then finally, modified this a little bit because I'm talking to veterinarians today. This is one example of the sort of advertising I found on the internet for, marketing the products to veterinarians for use in animals. So I'm going to go on to the next slide. I'm going to talk about the legal issues here, and then I'm going to go back to some of those slides and refer to them and point out some things for you. So in addition to the FDA, the USDA, the DEA, all saying that the 2014 Farm Bill did not allow these products to be generalized, just sold in a general manner, and the FDA stating that they believed that in effect the manufacturers of these products were violating the Food, Drug, and Cosmetic Act by introducing new drugs into the market when those drugs had not been approved by the FDA, had not gone through the FDA approval process. So what some of the manufacturers started doing was labeling the products as if they were dietary supplements. So they stopped making drug treatment claims. They stopped, some of them did, not all of them, but some of them stopped saying in their marketing, this is effective for pediatric seizures, or this is effective for anxiety in dogs, or something like that. They stopped doing that, those drug claims, which clearly makes the product a drug under federal law when you start making those claims. And they started selling them as if they were dietary supplements. So they might make what are called structure and function claims. It's like, well, this may have a calming influence on your nervous system. That's what's called a structure function claim, because they're not talking about treating a specific disease. Well, under federal law, dietary supplements can make those structure and function claims without being considered a drug and having to go through the whole new drug approval process. But the FDA has stated on numerous occasions that CBD cannot be sold as a dietary supplement. That's because there's a provision in the Food, Drug, and Cosmetic Act that says you can't sell something as a dietary supplement if it was the subject of an application submitted to the FDA to be approved as a drug. And the FDA has approved one product that contains CBD. It's called Epidiolex or Epidiolex, however you pronounce it. It was just approved in 2018. It's approved for use in humans for pediatric seizures. And the company submitted a new drug application to the FDA at least several years before these CBD products started to be sold. That meant that because CBD was a subject of a drug approval process, companies could not then come and start making dietary supplements. And so the FDA has basically said at this point, the products cannot be sold as a drug and they cannot be sold as dietary supplements. And then if you take a look at really both federal and state law, but I'm going to focus on state law because we're actually even a little bit more strict than the federal government is. We have no provisions in state law about dietary supplements, so we defer to the federal law for that. So if something truly is a dietary supplement like ginkgo biloba or something like that, under Minnesota's definition of a drug, we could actually consider something like ginkgo to be a drug, but we do defer to federal law, and if something like that can actually be sold as a dietary supplement, we allow it to be sold as a dietary supplement. But what Minnesota law says, and this is the second bullet point here, and there's actually one thing before I get to that bullet point. So our definition of a drug, which is in section 151.01 of the statutes, first starts off saying anything approved by the FDA is a drug, or anything that's listed in the United States Pharmacopoeia or the National Formulary is just de facto automatically a drug. None of these products are that because they've not been approved by the FDA. But then it goes on to say that substances other than food that are sold with the intent, not labeled, but with the intent to prevent, treat, or cure diseases, that's a drug claim, or to alter the structure and function of human or animal bodies are drugs. So as a matter of Minnesota law, if the intent of the sale of these products, not necessarily how they're labeled, so even if they're labeled as dietary supplements, and they have the disclaimer about, nothing here has been approved by the FDA, if the intent of the seller and the buyer is to treat a disease or to alter the structure or function of a human or animal body, the product is a drug. Now, if the manufacturers make no specific claims on the label or on any of their marketing materials or anything, it's obviously a lot harder to prove intent. But I have looked at many of these websites, and there's usually always something on the website that indicates what the intent is. They may not make specific claims, but they will make references. And that's why I'm going to go back to some of these slides. And some of these are actually outright drug claims. They're pretty dramatic. But if you take a look at this slide here, you have things in here in the lower right side. Benefits of CBD. CBD has strong antioxidant, anti-inflammatory, antispasm, anticonvulsant, antipsychotic, antitumoral, and neuroprotective properties. Nothing about a specific disease there, but that's a structure and function claim. That makes this product, under state law, a drug. Now, the next statement is more of a drug claim. Scientific and clinical studies have shown that CBD could be therapeutic for many conditions, including but not limited to chronic pain, cancer, anxiety, diabetes, etc. Those are all drug claims. Now, they are not saying that their product is effective for that, and a lot of them won't, because their product's never been tested, never had clinical trials. So what they'll usually say is, well, CBD can have these effects, and therefore we think our product will have these effects too. But that little box there is an example of both structure and function claims in the first paragraph and actual drug claims in the second paragraph. And that makes this particular product a drug under Minnesota state law. If you take a look at these products, the round container at the left is called Pain Freeze, Biocooling CBD, Triple Medicated Pain Relief Gel. Again, they're actually calling it a medication, a drug. I actually looked into this product. It's cooling because it also has menthol, and it's like CBD version of Bengay is what this product is. And then if you take a look at the gummies, and I've talked to agriculture a little bit about this, is this food or is this a drug? Because it's something that's edible. It has some minimal nutritive value, maybe, because it might have some sugar in it, so it might give you some calories, but it also talks about pain relief, combats anxiety, produces natural sleep, reduces stress, etc. And the hemp bombs bottle in the middle, extra strength CBD, complete relaxation syrup. That's a structure and function claim. And then, as I mentioned with this, it actually says it's medical grade hemp. And so these are all indications that those products meet the legal definition of a drug. And that's important because in Minnesota, drugs can only be legally sold if they are approved for use by the FDA, and none of these products have been approved for use by the FDA except for Epidiolex. The labeling has to be approved by the FDA. The product has to be manufactured by companies registered by the FDA and licensed by our board. And the manufacturer has to use current good manufacturing procedures for drugs, which are designed to make sure that there's consistency between the batches. So if every batch, or if the label claims that it has 5% CBD, every subsequent batch will have 5% CBD within a very narrow range. And to the best of our knowledge, these companies are not necessarily following those current good manufacturing procedures. If any one of those elements is missing, not all of them together, but if any one of them is missing, the product is either misbranded because its labeling is not approved, or its labeling is false and deceptive because it's making unsubstantiated claims, or it's adulterated if they're not following current good manufacturing procedures. It's actually a crime under the Pharmacy Practice Act to sell misbranded or adulterated products. It's not a crime to purchase them because the misbranding and adulteration laws, which were created decades ago at both the federal and state level, are designed to protect the public from people who might sell potentially hazardous products to them. So you're not punishing people for buying a product that might harm them. You punish the people who are selling the product that might harm them is the rationale behind that. And it's a crime at the state level. It's a misdemeanor. At the felony level, under the Food, Drug, and Cosmetic Act, it can be a felony. Although I think what the FDA typically tries to do is they try to, rather than engage their Office of Criminal Investigations, they first try to get people to come into compliance administratively and try to issue them warning letters, which they have done about some of these products, and then maybe fine them, which is an administrative or civil procedure before they start prosecuting. Also, I'm aware of only a couple of people who've been criminally charged with misdemeanors in this state, and it wasn't involving the sale of misbranded and adulterated drugs. One person practiced pharmacy without a license. He fraudulently claimed to be a licensed pharmacist when he wasn't, and somehow got himself hired. And the other was a retail establishment that catered to immigrants from West Africa that was actually selling penicillin over the counter. So there is one exception under state law, which is that products that are sold by the medical cannabis manufacturers licensed by the Minnesota Department of Health, they can be sold as allowed under that law, but that applies to humans. You have to get certified that you have one of several, actually maybe at least half a dozen different conditions now. You have to get like a prescriber to certify that you have one of these conditions, and then you have to go and get the medication from the manufacturer. And our law is written, a pharmacist is actually involved in choosing the medication and dose for you. And none of that, of course, is happening with these sort of products, and they're not manufactured by one of the licensed manufacturers. So I've got a couple of veterinary-specific things that I found here. So the FDA has an FAQ document, and I've given the link here, about the sale of both hemp and the sale of marijuana and the sale of CBD and THC when it's extracted from hemp or marijuana and put into other products. And so one of the questions is, in this FAQ document, is it legal in interstate commerce to sell the food, including any animal food or feed, to which THC or CBD has been added? The answer is no. It's prohibited to introduce into interstate commerce any food, including animal food or feed, to which has been added a drug product. And so we don't regulate foods here. The Department of Agriculture does, but they confirm for me. I just had a meeting with the head of their food division last week who confirmed that our state agriculture department enforces federal law when it comes to foods. And in fact, they're under contract apparently to the FDA to do some of that enforcement. And so they have been going out and, for example, they've found companies that have put CBD into coffee, and they have shut them down. There was one brewery that was making CBD infused beer. They shut them down. And so they're doing that under federal law, which they enforce, and they're contracted with the federal government to enforce. And I'll explain in a little bit why the board hasn't really done much in the human world, and I've got a slide about that. So here's another thing, and I think this is meant for both veterinarians and pet owners. I've seen cannabis products being marketed for pets. Are they safe? And again, just highlighting some of it, FDA has not approved cannabis for any use in animals, and the agency cannot ensure the safety and effectiveness of these products. FDA cautions pet owners against the use of such products and recommends that you talk with your veterinarian about treatment that really is appropriate and proven. I think is the message they're trying to get back there. So what could we do, and why haven't we done it? So we have the authority under our Practice Act, and the first thing we've had for decades is if we find that a drug product is misbranded or adulterated, we can embargo the product. And that simply means we don't seize the product. The FDA can actually seize misbranded and adulterated products and take physical possession of it. We don't do that, but we would give the seller paperwork, and we've done this, like that African store. We embargoed it and we did the cease and desist order, but we give them paperwork that says that these products are misbranded or adulterated, and you are prohibited from selling them or even removing them from the premises until you're given permission to do so by either the board or the court. But then what we have to do is within 30 days, we have to go to the district court where that facility or establishment is located and ask the judge to issue an order of condemnation. If the order is granted, then the seller has to have the product properly disposed of at its own expense. A much newer authority that we've only had for maybe 5 or 6 years is the authority to issue cease and desist orders. And in this case, we're not looking necessarily at a particular product, although we might be, but what we are doing is we're ordering the individual or the business to stop breaking the law the board enforces, basically. So the cease and desist authority says that anytime we become aware that someone's breaking a statute or rule that we enforce, we can issue an order to tell them you have to stop violating these statutes and rules, and this is why. In this case, it's the affected person or business that would have to file suit against us in Ramsey County Court and try to convince the judge that the board was wrong in issuing the order and the board order should be vacated. If they don't go to Ramsey County District Court I think it's within 30 days, or if the judge rules in our favor, the order becomes permanent, and then they have to stop doing what they're doing. If they don't, we go back to district court and try to get the judge to issue an injunction stopping them. And in that case, if they violate an injunction, that's contempt of court, and they can, my understanding is they could potentially be jailed. So why hasn't the board done these things? Well, again, one of the metaphors I use is it's the wild, wild west. The other one is the genie's out of the bottle. By the time I became aware of this 14 months ago, these products were everywhere. And so we literally don't have the resources to go after all of the companies, both here and on the internet, that are selling these products. I mean, one of the things I've kind of half jokingly asked the media and half seriously is, do we issue a cease and desist order to Jeff Bezos at Amazon.com? Because the last time I checked, they had 7 full pages of the products. So that was part of the reason is we don't have the resources. We haven't had any complaints of anyone being harmed by the product. If we do, we will investigate and we will take appropriate action. Part of it was when we first became aware of this last fall and into the early winter, there was a lot of talk that Congress was going to do something. And I'll talk about that in a little bit. They did, but they still didn't make it legal. And we thought the legislature might act, which they did, and I'll talk about that as well. Now, what we have told pharmacies is because they are our licensees and because we have a provision in our Practice Act that says it's unprofessional conduct for pharmacists and pharmacies to violate any federal, state, or local statute, rule, or ordinance related to the practice of pharmacy. We've told them they cannot sell CBD products within the area of the store that we license as a pharmacy. We told them if they sell it in the front end and the pharmacist is not involved in the sale, we're going to handle them like the grocery store down the block. If we get a complaint, we'll investigate it. But we don't want it in the licensed area. We also tell them that if they ever do decide to sell the product, they want to probably check with their malpractice insurers and their attorneys about their liability if they sell the product. So 2018 Federal Agricultural Bill, first of all, it clarified that hemp and its derivatives are not controlled substances. And this is another thing that the industry, I think, was banking on. They kept saying, well, the 2018 Act made this legal, but they're only focusing on one half of the legal equation, because there was always been this question, which is why law enforcement was interested about whether this is a controlled substance. Because if you possess controlled substances, that's a felony under federal and state law. And so our legislature in 2015 actually did take CBD derived from hemp out of the schedules because of the way that they defined hemp. They defined hemp as a product that contained less than 0.3% THC, and they specifically said hemp is not marijuana. And the only reason CBD was ever a controlled substance is because it was a derivative of marijuana. CBD is not independently listed by itself in Schedule 1 of the controlled substance. It was only scheduled because it was derived from what was considered to be a marijuana plant before you had this distinction between marijuana and hemp. Now there is a distinction under state law, and anything derived from hemp is not derived from marijuana, and therefore it's not a controlled substance. That's exactly what Congress did in the 2018 Farm Bill, and we at the state level in 2019 identified that as well. And now it's clear that even if CBD is derived from marijuana itself, as long as the final product has less than 0.3% THC, it's not marijuana, it's not a derivative of marijuana, and it's not controlled. So none of these products are now controlled substances. That is definitely happened. But the language actually explicitly now states, which the 2014 Act didn't do, it explicitly states that nothing in the hemp provisions waives any of the provisions in the Food, Drug, and Cosmetic Act. So like the same day, or maybe the next day the bill was signed into law, the FDA issued a statement reiterating that CBD products could be considered misbranded and adulterated if there were any drug or structure and function claims made. They did say they would try to work to amend rules to allow CBD to be sold as a dietary supplement. They have not done that yet, and they have since said that Congress probably has to do that. And they did take some public testimony, so they're trying to recognize that people want to use the product and sell the product, but it is still illegal. And then in the 2019 Minnesota Health and Human Services Omnibus Bill, which Governor Walz signed into law on 5/31/19, it did pass provisions that I drafted for a senator. I really didn't think it would get passed, but these provisions are such that effective January 1st, 2020, if certain conditions are met, certain products will be allowed to be sold under Minnesota law, but still not under federal law. And the provisions are this: the product has to be tested by an independent third-party lab to verify the CBD content, because some of those products you saw were tested by the agricultural product. That CBD cigar said it had 15% CBD, it had 7% CBD. Also to verify that no more than trace amounts of THC and heavy metals are present. The product has to have labeling information that it has contact information about the manufacturer and the lab. There has to be an accurate statement of the amount of cannabinoids in the product, and a statement like the dietary supplement statement that no claims, they actually can't make the claims, but they still have to say that the product doesn't claim to treat, diagnose, cure diseases unless that's actually approved by the FDA. And this applies to products that are meant for use in animals. There's no distinction between federal and animal laws as regards to, in this state, as regards to CBD. And that's what I have. I don't know if this cuts off abruptly at one, but if you have questions, I'll stay on and answer them. If I don't get to them now, you can send me an email to my contact information and I will answer them. But in a nutshell, the CBD products, despite the claims of the manufacturers and sellers, have never been legal to sell under federal or state law. This new Minnesota law, if it goes into effect, or when it goes into effect, if the products meet those conditions, they will be legal for sale under state law, but they won't be under federal law. Any questions?
Okay, I'm not seeing any quite yet.
Okay. I can
so we'll give people just a second to type in the chat box.
And I can stay on a while. Yeah, and while people are maybe typing in, I'll mention one other thing. One of the alternatives to passing this legislation that was also making its way through also got passed. And so there was a provision for the Department of Health to convene an advisory work group to make recommendations back to the legislature about regulating these CBD products that I am part of as well. And I'm on this task force, this committee. People from agriculture, health, public safety are all on the committee. And we'll be issuing a report to the legislature about what needs to be done. It'll just reiterate that these sorts of things that they already passed need to be done. And it'll clarify that this law, by the way, only deals with products that are under the jurisdiction of the Board of Pharmacy. I should mention that too. So this is things that really look like drugs can be legal. Food products that have CBD are still not going to be legal, even under state law on January 1st, because this does not cover food products. And there's this myth. Yeah, go ahead.
We just had to go ahead and finish, and I'll ask the question.
Just going to say, what I met with the director of the food division about last week is they've basically decided they have the federal laws and not allow CBD in what are clearly food products. But what they're going to say also is that if the manufacturer extracts CBD from hemp and puts it in a food type oil, like medium chain triglycerides, which might otherwise be a food, they're going to say that that does not make this a food product, because those oils are usually meant to be put sublingually under the tongue. So we're going to consider those to be drugs that could legally be sold if it meets these requirements. And go ahead.
So the question is, as of January 2020, as veterinarians, are they legally able to provide dosing recommendations when clients ask?
The question for Julie Wilson and the veterinary board. They're legal to sell under state law, and what we have told pharmacies is that, notwithstanding the fact that we have this statutes on the book, that we could pursue disciplinary action against them if they break federal law. We're going to recognize that our state is allowing for this, and so if they sell products like this, we are not going to take action against them simply for selling the products. We have told them, however, that just like when they make any recommendations for any sort of drug or even a dietary supplement, that the recommendations that they make have to be based on something. We expect pharmacists to exercise professional judgment, and as we've told pharmacists, that's not something you get just when your degree is conferred. You need to have some basis for this. We once told a pharmacist he either needed to stop selling this dietary supplement or we would discipline him. It was a legal dietary supplement, but he was making claims that it could cure cancer, and there was absolutely no evidence it could do that. And so he agreed to stop selling it and making those claims. It'll be the same thing here. If pharmacists want to sell this because it's now going to be legal under state law, and the legislature apparently is okay with this, the product being sold, we're not going to say they can't do it because it's still legal under federal law, but we are going to say that if they make any recommendations at all, including dosing or anything like that, you need to have evidence, and something more than the company probably provide you, because the companies are often making unsubstantiated claims themselves. But that's for our board. And I think the Board of Veterinary Medicine, the Board of Medical Practice, if they get questions from physicians about should physicians be recommending this in dosing, I think that's going to have to be up to each board to decide what they want their professionals to do with products that might be legal under state law, but still illegal under federal law.
Does anybody have any other questions? I'm not seeing any at this time. So I would like to thank you, Dr. Weiberg, for participating today. And I think most people know how to get a hold of you if they do have further questions, or they know how to get a hold of Dr. Wilson also. And if you don't, you can call the MVMA office and we will direct you to the appropriate individual. So go ahead.
Just in closing, again, I'm sorry I was late. Just one other thought I didn't really get out there. One of the other reasons that our board has not aggressively pursued this is we actually think CBD has value. It is pharmacologically active. And so it does have potential. We're worried about a lot of the claims that are being made that aren't substantiated, but it does have potential based on some studies in animals and even some studies in humans. Our concern is the industry just got way ahead of itself and started putting out products which could be of dubious quality that, again, don't even have the amount of CBD that they're stated, and they're making some claims that are not at all substantiated by any study I've ever seen. So, but another reason is, we don't necessarily want to deprive people of products that they really think are beneficial as well. And we'll continue working with our legislature to tweak this and with the other agencies I've mentioned. And I'll continue hoping that Congress ultimately does something to clear this up nationally and provide some national standards. With that, thank you for listening. And again, sorry I was late.
Thank you very much.
All right.
Have
Bye-bye.
a great day. Bye.